Good morning, Mr. Stevens.
Good morning, Sir Brown.
You're at home, are you?
I am, and thank you very much for giving me the opportunity to be so.
Not at all. It's what we have to do in the particular circumstances we find ourselves in at the moment. Now, let me tell you who you're talking to. You're talking to a room here in Fleetbank House in which there are 3 members of the legal team opposite me. There are 3 members of the inquiry staff, one of whom is Mary, who will ask you to take the oath in a moment or two. And there is Shoemake, whose job it is, which he does with great professionalism, I have to say, is to make sure that the right document is shown to you at the right time and highlighted in the appropriate place. Beyond us, there are probably somewhere around 200 or so people who will be watching. So although you're talking immediately to us and more immediately in answer to Ms. Richards' questions, you'll be talking to an audience of at least 200. It may very well be more because of the particular interest that your evidence will have. But thank you very much for coming. Ms. Richards.
I think Mary's going to swear the oath first. Administer the oath first.
Please state your full name.
Peter Roger Stevens.
And repeat after me. I do solemnly, sincerely.
I do solemnly and sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Mr. Stevens, can you see and hear me?
Yes.
Now, you were a trustee of the Macfarlane Trust from 1988 to 1992.
Correct.
And during that time, you were also a trustee with the 2 Macfarlane Special Payment Trusts, MSPT
Correct.
1 and 2.
Yeah.
You then had a second stint at the Macfarlane Trust as trustee and chair, 1999 to late 2006, beginning of 2007.
Yes.
You were chair of and trustee of the Eileen Trust, 1999 to 2017.
Yes.
You were involved in the establishment of the Skipton Fund from 2003 onwards and were a director of the fund until 2017.
Yes.
You were also involved with MEPT Limited.
Yes.
And you were a trustee of Caxton, the Caxton Fund, from 2011 to 2013.
Yeah.
Now, I'm going to be asking you questions today largely about the Macfarlane Trust and hopefully also the Eileen Trust, and then tomorrow about Skipton, Caxton and some more general thematic issues, just so that you understand where the questions are going. Mr. Stevens, you provided the inquiry with a written statement, and you were provided with quite a lot of documentation for the purpose of that statement. But I understand you've seen more documents since finalising your statement, which has prompted your memory in a number of respects. Is that right?
I wouldn't necessarily have prompted my memory, but certainly I was supplied with a lot of documents after my statement was written. And there are places where the written record, which I had forgotten, would supplant my poor memory.
We'll hopefully address those issues in the course of today and tomorrow. And at the end of tomorrow, if there's anything in your statement that you particularly want to raise or address or correct, I'll ensure that you have the opportunity to do so.
Okay, thank you.
Prior to your first involvement with the Macfarlane Trust in 1988, could you just tell us briefly what your background and employment history was? Your employment history prior to becoming involved in it with the Macfarlane Trust.
Yeah.
What had your work been, and what were your qualifications?
I worked in a number of mostly financial roles in 3 companies, and latterly during the time that I was involved with the Alliance House, with the firm of international insurance brokers called Willis, and I got into my involvement with Macfarlane Trust stemmed from a previous short period as a trustee of the Haemophilia Society, where the Reverend Prebendary Alan Tanner got to know me and asked me whether I would join him as a trustee of the new Macfarlane Trust. I wouldn't say I had any particular qualifications for it. It just, he asked me, I suppose, because of my general experience.
So you were appointed, I think, in around March 1988, and I won't go to the records, but we can see the first meeting you attended as a trustee was April of 1988.
I missed the first board meeting. After that, I suppose I tried to attend most of them, but there were occasions when I couldn't.
Did you have any, other than the brief time you'd had as a trustee of the Haemophilia Society, did you have any prior experience in the management of charities?
No.
And when you took up the role as trustee, was any training arranged or provided for you and your fellow new trustees?
I don't think. After all, the whole thing was new. We were all new to the job. I don't think we ever had any formal training.
What did you know at that time when you accepted the Reverend Tanner's invitation to become a trustee at MFT? What did you know of the circumstances in which people had been infected as a result of blood products?
I had 2 sons, both of whom had haemophilia. My oldest son contracted HIV. I subsequently, after he died in 1989, I subsequently saw his autopsy report. And to my untutored eye, the damage done to his internal organs would suggest he had Hep C as well. My younger son, who is now 50, contracted Hep C, but not HIV. He is now eliminated Hep C and is fit and well.
Can you tell us what, broadly speaking, were your responsibilities as a trustee of the Macfarlane Trust in that first period, 1988 to 1992? What practically did you have to do, and what kind of decisions did you have to make?
I think I was broadly simply a trustee to help to join in with the other trustees in consideration of the policy and execution of the policy of the trust. I was specifically charged with addressing or trying to address the perceived need for mortgage and insurance, life insurance, solutions to the problems that the trust residents faced. Other than that, I don't think there was anything particular I can remember about my role.
And what, in practical terms, did participation as a trustee entail in that over that 4-year period? There was attendance at the regular trustee meetings. Was there anything else in particular that was required of trustees that you can recall?
I don't think so. I don't believe that I did any visits to any haemophilia centres then. That came later. I don't believe at that stage the Trust organised any weekend events, for example. Those, I think, all came later. No, I think I was simply a trustee.
Now, you were a Haemophilia Society nominated trustee, as I understand it. Did that give you any particular or different responsibility as a trustee than other trustees?
I don't think so. There were, as I recall, the board at that stage contained 6 people nominated by the Society, 4 nominated by the Department of Health. I never received, that I can recall, any instructions or requests from the Society. I was simply, as it were, on my own, a free agent, making such decisions, giving such judgment as seemed to be right to me as an individual.
Now, do you know why the Macfarlane Trust was established as a trust rather than taking some other form? Was that something you were involved in?
No, I wasn't involved in the establishment at all. I mean, I can only surmise that it was because it was set up, I think, at the instigation of the government as a charity. It had to be, in those days, I think, charities and trusts were quite closely linked, and so it was set up as a discretionary trust with charitable objectives.
And when you took up your role in 1988, what did you understand to be the reasons for the establishment of the Macfarlane Trust and the purpose of the trust at that point in time?
To provide support, basically financial support, to people with haemophilia who had been infected with contaminated blood, with HIV.
Just going to ask you to look briefly with me at the trust deed, the original version of the trust deed. Seamus, it's MACF 603_064, please. And if we go to page 5 and look at paragraph 4, we can see there the objects of the trust set out. The objects for which the trust is established are to relieve those persons suffering from haemophilia who, as a result of receiving infected blood products in the UK, are suffering from AIDS or are infected with human immunodeficiency virus and who are in need of assistance, or the needy spouses, parents, children and other dependents of such persons, and the needy spouses, parents, children or other dependents of such persons who have died. Did you understand, as far as you can recall, the trust deed to draw any particular distinction between those who were infected and their dependents?
I don't think at the time I was aware of any distinction between those two groups. I think there was a distinction did emerge in the trustees' treatment of the groups, but it wasn't embodied in that objects clause.
And we'll come on to look at some of those issues at a later stage, Mr. Stevens. And then if we just, while still looking at the trustee, we can see, for the sake of completeness, paragraph 5, in furtherance of the above object, but not further or otherwise, the trustee shall have power to provide or assist in the provision of financial aid, holidays, food, clothing, and other articles or assistance in kind, or of shelter, hospice, housing, or other accommodation, whether temporary or permanent, promote the education of and provide scholarships and apprenticeships for children and young persons who are in need, collect and receive funds, donations and legacies for the promotion of the above object, provided that the trustee shall not undertake any permanent trading activity in raising funds for the above objects, and 4, do all such other lawful things as may be calculated to further the attainment of the above objects, provided that nothing herein contained shall permit or be deemed to permit the doing of anything or the pursuit of any purpose which are not exclusively charitable. Now, want to ask you about one early meeting. If we look at MACF 602_015, please, Shomik. You'll see, Mr. Stevens, this is a meeting of the trustees on the 2nd of May 1989 in which you were in attendance. If we could go to the bottom of the second page, please, Shomik. You'll see in the last paragraph, go to the bottom of the page. There's a reference there to infected partners. An application for registration by a once common law wife, now separated from the registered partner, was rejected pending further consideration, though it was agreed that in the meantime help could be given with expenses. And then this, it was, and if we go to the top of the next page, agreed that advice should be sought from the ministry as to the original intention towards spouses and as to whether those who became infected were eligible to be registered in their own right and not solely as dependent. It would appear from that record that questions as to the intention of the trust were regarded as matters for the department, the DHSS. Is that right?
Yes.
And why was it regarded as something upon which the department's advice would need to be sought rather than the trustees forming their own view?
Because the trust was set up at the instigation of the government and the department, and the department was responsible to the government for the running of the trust. So it was right that we should go to them and say, what did you actually mean?
May I just ask, why was the department responsible to the government for the running of the trust? Why weren't the trustees? It was an independent trust, was it not?
Yes, the trustees we were independent. We were certainly accountable to the Charity Commission, not to the department. But in the respect of the interpretation of the trust deed, which was, I believe, originally laid down in negotiation between Alan Tanner, his number two, Clifford Grinstead, and the department, I think it was right that we should go back to the department to say, what did you actually mean by this?
Well, the meaning would be a matter for the court, would it not, ultimately? Because the words used in making the gift or the setting up the trust are the trust, and once it's established, the further views of the set law don't matter, do they, in law? Did you take legal advice on this?
I have to take your advice. You're a far better lawyer than I. At the time, the trustees believed that the correct approach was to go back to the department to ascertain what was as it says there, the original intention towards spouses.
Thank you.
We can take that down. Thank you, Shomik. I wanted to ask you next about the arrangements for the appointment of trustees and employees, and these questions span both periods of time that you were at the Macfarlane Trust. Now, you've told us that there were a certain number of Haemophilia Society appointed trustees, a certain number of DHSS appointed trustees. Were any particular characteristics or experience deemed either desirable or necessary in selecting who should become a trustee, as far as you can recall?
I think we did occasionally specify either to the department for their nominees or to the society for their nominees certain skills we were after. I mean, I remember there was time when we felt that we were deficient in legal skills on the board. But I recall seeing a statement somewhere in the heap of documents about the department, that when the department were filling vacancies that they were required to fill, they were simply looking for senior, retired, or retired senior officials from the department, people who had some experience in medical and management matters without any specific skills.
As and when new trustees joined the board, what, if any, efforts were made, as far as you can recall, to ensure that those new trustees had sufficient knowledge of the background to circumstances in which people had become infected with HIV and had some understanding of its impact?
This is one of the areas where my written statement was at variance with what I subsequently found in the documentation. There was an induction pack prepared by our solicitors so that any new trustee would have a full grounding in the background and the purpose of the trust.
Now, in terms of chairmanship, the Reverend Tanner was chair for the whole of the first period of time that you were a trustee. And when you returned in 1999, you yourself, then I don't think I've got a record of the precise date, but you took up the position of chair. How was the decision made as to who should be the chair of the board?
I have no idea. Alan and Clifford invited me specifically to rejoin the board as a trustee with a view to replacing Alan when he stood down at the end of 1999, or I can't remember the precise date at which I took over from him in the chair. Sometime in 2000, I think, probably.
So you were invited to rejoin the board specifically so that you would become chair?
Yes.
But you don't know what discussions had taken place prior to you being approached?
I don't know whether there had been discussions with the other trustees on the subject, or with the society, or with the department.
Now, obviously, the Reverend Tanner had been chair of both the MFT, the Macfarlane Trust, and the Haemophilia Society. Was that something that you regarded then, or regard now as having advantages or disadvantages to have both those organisations jointly chaired?
Not really, no. No, the role of the society was changing over the years, and it was probably right that when Alan stood down from the chair of the trust, I don't know whether he was still chair of the society at that stage, it was probably right that his successor in the society did not follow him into the trust, but that an element of separation was created.
Well, were any attempts made to ensure that there was any form of representation on the Board of Trustees from Scotland, Wales or Northern Ireland?
I don't think there was, no. If there was, that was done by the society or the department. It was not done at the request of the MFT board.
Now, I think in the first part of your appointment, the 88 to 92 period, there was an administrator, and then by the time you returned in 1999, that role had been replaced by that of a chief executive. Is that correct?
My understanding is that Anne Hithesay, who replaced or succeeded Wing Commander Williams as the administrator at some stage during the period when I was away from the trust, felt that her job should be better seen as that of chief executive, and put that to Alan and Clifford, and that was accepted.
So when you were chair, there were, I think, two chief executives, first Anne Hithersay and then Martin Harvey. What was your understanding as chair of the role of the chief executive?
To make sure that the trust was executing the policies and the policies and the strategy determined by the trustees.
Where did decision-making responsibility or authority lie as between the chief executive and the board?
Decision-making responsibility was with the board. If the chief executive had any doubts about what he or she was being asked to implement, they would have to go to the chairman to find out what it was the board wanted done.
The Macfarlane Trust's office was in London, and I think, in fact, the offices of all the Alliance House organisations were in London, ultimately in the same location. What consideration was given to having some form of presence or office outside of London, in particular in Scotland, Wales or Northern Ireland?
At times when there was a lease termination or lease renewal coming up in London, there was from time to time some discussion whether the offices should be somewhere else. With the staff as small as that of the trust, it wouldn't be practical to suggest to think of having a satellite office anywhere else. So either the office as a whole would move or it wouldn't. Every time we reviewed it, we decided that the costs and the inconvenience to everybody, including the registrants, of moving the offices away from London were such that we would be better put to stay where we were.
What, if any, particular efforts were made to ensure that beneficiaries in all parts of the United Kingdom were able to access services and support equally?
Yes, I mean most beneficiaries looked first of all to their haemophilia centre for their care and well-being, and the haemophilia centre would work with them on approaches to the trust for assistance. There was an element of postcode lottery, if you like, here, in that some centres were better than others at providing this support, which we became aware of over the years. But generally, wherever they were, beneficiaries had equal access to the trust and to advice and help from their centres.
If we could look, please, at another document. It's a set of minutes from July of 1988, showing MACF 602_006. These are minutes of a meeting of the 20th of July 1988, at which you were in attendance. If we go to the bottom of the second page, please, Shomik. You can see from the very bottom of the page, this is after a discussion about securing premises at Alliance House. It said, it was agreed that the address should remain confidential and that a new PO box number be secured in SW1. Why was the address to be kept confidential and not shared with registrants?
As far as I know, the address was available to registrants through the society or their centres. I can't remember why we wanted the address to continue to remain confidential, probably to stop up to keep away unwanted callers. But I can't remember.
Could we look at another set of minutes, MACF 602_011. You'll see, Mr. Stevens, these are minutes of a trustees meeting on the 9th of December 1988. Again, you were present. If we go, please, Shomik, to page 6. You'll see, if we look at the top half of the page, that in fact in this early period in 1988 you did go on some visits at least to haemophilia centres. It records here 2 Scottish visits, meetings in Glasgow and Edinburgh. And if we just go down the page to the second half of the page, please, Shomik. We'll see in relation to Glasgow, it's described as there being some initial anger directed at 4 points: the inadequacy of the 10 million fund, the decision by trustees not to pay all or most of the fund immediately on a lump sum basis to everybody, means testing, and then the fourth is about a specific request. I'm going to pick up on some of these themes with you later, Mr. Stevens. But if we go to the next page, we can see top half of the page, there's a reference to the visit to Edinburgh, and the second paragraph reads, a considerable amount of time in addition was spent discussing the limits imposed upon us by the trustee, and anger was expressed at the fact that copies of the trustee had not, as a matter of course, been sent to everybody. Now, I'm not going to take you to too many documents unnecessarily, I hope, but if you take it from me, Mr. Stevens, there's another set of minutes which shows that trust deeds were going to be sent, copies of the trust deeds were going to be sent to haemophilia centre directors. Is there any reason why the MFT had not made arrangements to ensure that all potential beneficiaries had a copy of the trust deeds?
I can't think why that. I don't know whether that was a conscious decision or simply we didn't get around to it. I don't know.
And then if we look at the bottom half of this page, under the heading Summary and Recommendations, point 2 refers to the depth of anger expressed in both Glasgow and Edinburgh, and a suggestion that there should be similar meetings at all major centres. And then at 3 it says this: the Society's assistance should be sought to assess which centres are most likely to contain particularly embittered people. These centres should be seen sooner rather than later. It's understood that Cardiff might be a prime candidate. Why were people being identified there as potentially particularly embittered? Why that choice of words? This is your document, I should say.
I suppose by then we or the Haemophilia Society had picked up the fact that there was particular anger in Cardiff. I couldn't tell you why. And I'm sorry that in my earlier answer, I had forgotten entirely about these visits.
Before we look at some of the early decisions of the Macfarlane Trust in that 88 to 92 period, I just want to ask you a little about the 2 special payment trusts. The first special payment trust, MSPT1, was established in early 1990. I'm not going to go to the original trustees. And is this right? It was to administer what were called ex gratia payments of £20,000.
Yeah.
And if we look at a set of minutes of the Board of Trustees discussing this, it's MACF 602_020, please, Shomik. You'll see, Mr. Stevens, if we look at, thank you, these are the minutes of an extraordinary meeting of the trustees held at Alliance House on the 29th of November 1989. And if we look at the bottom of the page, you'll see reference there on the 21st of November, the Trust and Haemophilia Society had been invited to a meeting with the Secretary of State scheduled for 12:45 on the 23rd of November. No detailed agenda or papers have been provided in advance of the meeting. And if we go to the next page, we look at the top half of the page, we can see at the meeting it quickly became clear that the Trust and Society had been invited to be told the government's intentions only just in advance of an official parliamentary statement and press release. There'd therefore been no negotiation and very limited scope for discussion, though the views of the Trust and the Society had been firmly presented to the extent that the draft statement and press release had been modified in some areas. The Secretary of State had made it clear that the government did not intend to alter its position that compensation must be handled by the courts, and hence that the proposed payment was not a settlement or compensation payment. And then there's a reference to the chair as on behalf of the Haemophilia Society saying this was just the beginning. And then if we go further down, there's reference to the Secretary of State being asked why the government didn't make the payments itself. The response was using the trust was necessary to give concessions on tax and social security payments. The government proposal was to pay the trust £19 million and for the trust to provide the balance and be later reimbursed. I don't know what, if any, recollection you have of these events, Mr. Stevens, but it would appear from this that the Macfarlane Trust had little advance notice of, or little advanced involvement in the government's planning of and its announcement of this payment of £19 million. Is that your recollection?
Yeah, I think you probably have to consider both the special payments trusts together, because the first one, the ex-gratia payment, was set up in order to forestall brewing litigation by beneficiaries, registrants against government. It was a failure in the sense that it didn't actually forestall this litigation at all, and they had to move on to MSPT2. But MSPT1 was an attempt to buy people off, I think, with £20,000 each. And you can see that from that paragraph, the central paragraph there, that the government had absolutely no understanding of the words that came up in the earlier consideration of the trustee. There's a phrase, exclusively charitable. They had absolutely no idea that MFT could not make these payments, which were not charitable. It was simply ex gratia, £20,000 to everybody. That was a failure that ran all the way through the entire period that I mustn't exaggerate here, well, certainly all the way through well into this century. The failure of the government to appreciate that the charities were charities and could only act on the basis of charity law. They could not just hand out money because the government thought it was a good idea.
If we go to, before we leave this page, we can see from the paragraph below that it says the government proposal was to pay the trust £19 million and for the trust to provide the balance and be later reimbursed. Can you recall this issue or this suggestion that the trust would somehow contribute to this and then be reimbursed?
No, I mean, this is an outrageous suggestion by the government that the trust should provide any of the money at all and be later reimbursed, or even pay out, or let alone handle the payments out of the trust. It just showed complete lack of understanding of what they had set up.
And if we go to page 11 of this document, please, Shomek. We can see there a reference to advice it appears the Trust received from the Charity Commission in that regard. And then the bottom of the page, you'll see their reference to a missing £5 million trust monies couldn't be directly involved. Is that what the government was expecting the trust to contribute, and 5 million that the government would somehow then later pay back to the trust?
Yes, I mean, if you say £20,000 each, and there are about, at that stage, there are about 1,200 people registered within the Macfarlane Trust. That's 24 million. So 5 million is the gap that they thought that the trust could find and pay out. It is ludicrous. It is absolutely laughable that anybody in government or in the department could have thought that this was possible.
And if we could go back 3 pages to what I think is probably page 8 of the document, Seamus. So this is a draft press notice dated, which was being considered by the trustees meeting on the November 1989. I don't think we have the precise date of it, but it refers to the original 10 million, which had been provided in 1988 to set up the MFT in the first place, and then the additional 19 million. And then it records Mr. Kenneth Clarke saying this: the government had 2 objectives in mind. First, to enable the trust, if the trustees see fit, to make individual payments of £20,000 this year. These would go to each person with haemophilia. Second, to enable the trust to continue on a more generous scale their help to families in particular need. If the £19 million was going to be used, and indeed wasn't quite enough to make the payments of £20,000, do you understand how it could be said that the 19 million could enable the trust to continue on a more generous scale their help?
Sorry, I didn't hear the question.
Mr. Clarke, I'll rephrase it more clearly. Sorry, Mr. Stevens. Mr. Clarke says there are 2 objectives in making this payment. The first is to enable the individual payments of £20,000.
Yeah.
And that's what's ultimately done through MSPT1. But secondly, he says the government's objective is to enable the trust to continue on a more generous scale their help to families in particular need. As I understand it, Mr. Stevens, none of this £19 million was going to ended up going to the MFT to pay out in accordance with its charitable objectives. So, do you understand how the government was able to say that this payment was to enable the trust to be more generous in its help?
Probably through political or official idiocy. I mean, it's just ludicrous. Ludicrous.
We can
just before we leave that, can you help me with the phrase that Mr. Clarke is reported to have said? It's to enable the trust, if the trustees see fit, to make individual payments of £20,000 this year. That suggests, though the rest of the paragraph would be to the opposite, that there was an element of discretion
Yes.
about the payment to individuals of the sum. The following say this would go to each person with haemophilia who is infected. In other words, that's a payment to which someone's entitled and there's no discretion about it. How did you read what he was saying? Were the words, if the trustees see fit, an attempt to make this structure fit with the discretion which the trustees would otherwise have as trustees?
Yes, I can only suppose that somewhere in the department and the government there was a glimmer of understanding that the trustees of MFT could only make payments on a discretionary basis. So they put in these words, if the trustees see fit, to make it possible that MFT could make the ex gratia payments.
I mean, if the purpose of paying it through the Macfarlane Trust one way or the other was to ensure that the payments in the hands of the beneficiaries were not taxable and did not affect benefits, they would have to be discretionary, as I understand what the previous document was suggesting. Whereas this reads to the opposite, but includes this SOP, if it is a SOP, to discretion. It's very curious.
Yes, if it wasn't for the fact that I was involved for so many years through the various organisations with the Department of Health, I would say that it was impossible that this could ever have been drafted, could ever have been written. But unfortunately, it became all too obvious that this is the way the department and the government worked.
What in fact then happened is, as I understand it, the Macfarlane Trust said it couldn't proceed in this way. Hence, the Macfarlane Special Payments Trust, MSPT1, was set up.
Yes, I can't tell you what the timescale was, but when we said when we got that message across, but I think it probably happened fairly quickly.
And is this right? The role of MSPT1 was simply on a non-discretionary basis to administer the payments of £20,000?
Yes. The Macfarlane Trust, MFT, had the database. People involved, their addresses, their names, addresses, and bank details. So it was very easy to have another organisation set up that could have access to that database. Whether or not we asked people whether they minded, I suspect we probably didn't in those days, but maybe we did. And so MSPT1 MSPT, as it was then, was set up simply to get these payments out, which we did fairly quickly.
Now, an issue then arose as to whether receipt of the £20,000 payment should be taken into account by the Macfarlane Trust when it was considering applications for assistance. And if we look at MACF 602_022, please, Shomik. We can see that these are the minutes of a trustees meeting on the 22nd of March 1990. If we go to page 7, please. You'll see there, Mr. Stevens, under the heading Allocation Policy, a heading the implications of the £20,000 ex gratia payment. And there is then a debate about whether the ex gratia payment should be taken into account when assessing applications for grants. And if we go to the top of the next page, we look at the first paragraph. The final majority view is that no direct account should be taken of the ex gratia payment in assessing grants by the Trust. And this was seen as a continuation of existing policy. At the same time, it was recognised that it would be difficult to guarantee that trustees' awareness of the grant could be entirely set aside, and hence may affect their view of some requests for assistance, such as mortgages or house improvements. So that was the view taken by the board. Your own view is what I wanted to ask you about, Mr. Stevens, and that requires us to look at a different document. It's HSOC 20-13492, please. HSOC 00-13492. This is an exchange of correspondence between you and Mr. Waters of the Haemophilia Society. If we go to the third page, please, Shomik, we can see your letter. And if we look at the first half of the page to start with, you refer in the second paragraph to the letter having been discussed at the trustees meeting. Those are the minutes I think we've just looked at. And then you say in the third paragraph, in my opinion, as I told my fellow trustees, the 20,000 ex gratia payment cannot and indeed should not be excluded from our consideration of future requests for financial help from the Trust. In many cases, it will not be relevant, but as I've expressed to you in connection with the campaign as a whole, I believe that with scarce resources, we must be prepared to discriminate in favour of those in most need. and the £20,000 payment is an obvious factor in helping to determine such need. You go on to say that clearly £20,000 cannot be considered sufficient compensation, underlined, nothing can, and you know that's said with personal experience. And then you talk about in that and the following paragraph of different degrees of disadvantage. And you say in the following paragraph, the family men or their surviving widows and families remain in general in need of assistance, and it's to them that I feel that the Trust should give priority. I shall continue to urge my fellow trustees, therefore, to take into account the ex gratia payment when considering applications received from those who fall, for example, into the first two groups I describe, in order that we can be more effective in our help to others on whom the burden of HIV infection falls even more severely. It is, of course, possible we'll not receive many applications from those former groups, in which case the issue will rarely arise. Two questions, Mr. Stevens. The first is, why was it, in a nutshell, your view that the £20,000 should be taken into account, at least in some cases?
I don't know why. That was my view. It is actually still my view, funnily enough, 20 years later, whatever it is. If you like, there's a phrase that has come up in various times during my career of the Daily Mail test. How would it look to the readers of the Daily Mail if they discover that this group of people were being given £20,000 and were then also being given other money from the same source, the taxpayer, that did not take account of the £20,000. I just felt, and still feel, that the whole financial picture needs to be should have been looked at and should be looked at. It wasn't the opinion of the majority of the board, as it said at the top of the previous page, and I had to go along with the majority. But as I said there in my letter to David, I would continue to urge my fellow trustees to take into account the ex gratia payment.
The board's minutes had, although reaching a view different from yours, had acknowledged that it might be difficult for trustees to avoid consideration of the receipt of the £20,000.
Yeah.
As a matter of fact, can you recall whether applications for assistance were rejected, in part at least because it was thought by trustees or by the administrator or the allocations subcommittee that rather than come to the Macfarlane Trust, beneficiaries should use the £20,000 ex gratia payment?
I can't recall that happening as a matter of fact. No.
Turning then to the second Special Payments Trust, which I'll refer to for shorthand as MSPT2. Now that was set up in 1991, and that was pursuant to the settlement agreement in the HIV litigation. Is that correct?
Yeah. I wasn't involved in the discussions about setting that up, but I have to assume that the negotiations were between the department and the solicitors acting for the litigants, with peripheral involvement from the Macfarlane Trust.
And is this correct, that MSPT2, again on a non-discretionary basis, made payments, the rate varied, but made payments in accordance with the amounts agreed as part of the settlement?
Yeah, there's a tariff agreed, and we made payments according to that tariff, provided the applicants signed their waiver of litigation rights.
That's the next question next matter I wanted to ask you about. If we can just to contextualise this, look at the settlement agreement. I appreciate you weren't involved in those negotiations, but if we just look at DHSC 301942. So you'll see HIV haemophilia litigation, the main settlement agreement, and it refers to the Macfarlane Special Payments number 2 trust to be established and sets out the tariffs. If we go to page 16, please. Paragraph 8. We can see their reference, it's not the only reference in this document, but just for sake of convenience, I'll just take you to this. Reference to the signing of an undertaking not to bring proceedings in respect of the administering of cryoprecipitate factor 8 or 9, save that they weren't prevented from bringing proceedings if the damage, point 1 is relation to date, and point 2 is the damage alleged does not include infection or the risk of infection by HIV and or the hepatitis viruses. So there's one of the references in the settlement agreement to the undertaking. What was the role of MSPT2 in evaluating the undertaking? Did you receive the assigned undertakings and or check somehow that there was a signed undertaking before the payments were made?
There were, whatever it is, there were 4 trustees of MSPT2. I was one, and we had meetings to go through applications, and we would sign off the payments to be made, provided the administrator, William Commander Williams, could assure us that the applicant was correctly assigned to whichever bit of the tariff he belonged to, and that the application was accompanied by a signed waiver. Now, paragraph 8 there only refers to qualifying non-plaintiffs, but there's somewhere there's a similar paragraph, I'm sure, that applies to plaintiffs. So nobody got a payment unless they had signed that waiver. The other interesting thing is, of course, that the reference to the hepatitis viruses, which I think was that the hepatitis C virus had only just been identified and isolated and named in 1990. I couldn't tell you what date it was in 1990. But generally, the people who signed this waiver, I think, did not know about the risk of hepatitis infection. There's not parity of knowledge.
Did you and your fellow trustees, do you recall at the time, have any qualms or concerns about the fairness or morality or of the waiver requirement?
I don't recall protesting or observing to the departmental officials, let alone the politicians, that there was something wrong here. We did what we were told.
We can take that down. Thank you, Shomik. Was there, as far as you can recall, any discussion within MFT about whether the monies paid under MSPT2 should be taken into account when grant applications were being assessed by the Macfarlane Trust?
I don't recall any discussion. I'm sure that if there was some, I would have been in a minority, maybe a minority of one. I can't remember.
I think it's clear from what you've said already and from a number of the documents that in this period, 1988 to 1992, the Macfarlane Trust's view was that it could only provide assistance in response to need.
Yes.
Do you recall whether in that period the Trust had received legal advice on that issue?
No, I can't recall that. I know it was extensively explored in my second coming, kept on coming up, and we took legal advice more than once. But I don't recall legal advice being sought first time around.
And at a fairly
Sorry, just to say the objectives clause in the trustee was pretty specific. Talked about need.
And I think at a fairly early stage, if we look at MACF 602_002,
One we've already had.
I'm not sure this one is. It may be. This is the very first trustees meeting. I think 29th of March 1988. It's the one you were not present at. You gave your apologies.
Okay.
But if we look at the third page, please. And we look at the second paragraph. Questions arose regarding a level of equal distribution to those people with haemophilia who'd come into contact with the virus. This position had been raised by the General Secretary of the Haemophilia Society with the solicitors. Their reply was circulated. Mr. Paisner made it very clear in that reply that equal distributions which failed to take account of personal circumstances did not fall within the terms of the Charities Act 1960 and could not therefore take place. This situation was accepted and regret was expressed at this limitation. So is this right? From the very outset, the Trust's position was, for the reasons we see outlined there, that it could not simply equally distribute the funds, which at that stage stood at £10 million.
Yes. Two comments. Firstly, that sometime in those first 4 years, we, the trustees, did introduce a system of regular payment, the flat rate regular payment to everybody at £25 a month. Justifying that on the basis that everybody who had haemophilia and HIV necessarily were incurring greater living expenses, and therefore some assistance had to be given with those higher costs. Whether or not Mr. Paisner would have accepted that, I don't know. The second point that I was going to make, like most things in my life these days, has escaped me. He may or may not come back.
Is it right to say that really from the outset there was a tension between the Trust's view that, having been set up as a charity and having the objects that we looked at in the trust deed, it could not proceed on an equal distribution basis but could only proceed in response to need, and the view of beneficiaries.
Yes, sorry, that was the second point I was going to make. That if you think back to the notes about the visits to Cardiff, to Glasgow and Edinburgh, one of the points in which anger was expressed was the fact that we simply didn't pay out £10 million divided between 1,250 people and just do that. I mean, there are various arguments against that policy, but one of them is the fact that that would not have been in accordance with our charitable objectives.
Would you agree it's, however, perhaps not surprising that beneficiaries, registrants, those infected and their dependents, saw or felt that the monies paid by the government to the Macfarlane Trust were monies that ultimately, having been paid in contemplation of or in threat of litigation in part, ultimately somehow belonged to them?
I don't find that surprising at all. I mean, it was clearly a wrong view, but it's not a surprising view. And it was one that we battled with constantly, all the way through, both the first 4 years and in my second appearance there. He was underlying view the whole time that it's our money, give us our money.
And this was a cause of tension throughout the period that you were involved in the Macfarlane Trust.
Absolutely.
What attempts were made, as far as you can recall, by the Trust to explain the limitations of its powers to the infected and affected community?
I suppose in newsletters and other documentation we would have attempted to put this view over. I can't remember. Unfortunately, the Mcfarlane Trust had too many registrants to be able to engage in personal dialogue with every one of them. Whereas with the Eileen Trust, well, the issues are much the same. It was very much smaller, and particularly in the later years, we were able to engage in individual discussion and make sure they understood the problem, and they did. And the caseworker Susan Daniels did a great job there in ensuring that people didn't have these misguided views and didn't take out on the trustees and the trust their anger that we had charitable objectives to fill that were overriding everything we did.
Now, as well as the decision at an early stage that you couldn't go down the route of equal distribution, a decision was taken at an early stage that it was inappropriate for the Trust to fundraise. And I just want to look at that with you, please. It's MACF 602_005, please, Shomik. These are the minutes of a meeting on the 7th of June 1988 attended by you, and if we go to the third page, we look at 88.32, so that's the any other business. Mr. Grinstead raised the question of future funding arrangements. This was discussed in some detail, and finally it was agreed that it would be inappropriate to fundraise in order to support the work of the Macfarlane Trust, and that further recourse when necessary should be made to the government. Why was the view taken that it would be inappropriate to fundraise?
We just took the view that the trust was too small, dealt with a very small number of people who certainly had been damaged very badly by the government. And the trust was being funded by the government. We thought we would both be unsuccessful in raising any funds, and that were we successful, the government would say, fine, you don't need us anymore. So either way, we thought it was far better to stick with the devil we knew.
Now, if we go...
Something was discussed many times over the years. It was formally raised there in a board meeting, but it was... We thought about this many times, and we always felt the same, that we were not likely to be very successful. Bear in mind that this was before crowdfunding and social media, so which these days seem to raise large sums of money for the most extraordinary specific causes. We didn't think that was open. Well, that wasn't open to us in those days. We didn't think we would be successful, but if we were, the government would wash their hands of us.
Another early decision was about not campaigning, and if we look at MACF 602_019, these are the minutes of a meeting 20th of November 1989. If we go to page 3, please. Under the heading, the compensation campaign, discussion on this subject was wide-ranging but mainly centred on two aspects of trust policy, namely what part, if any, should the trust play in the campaign, and secondly, what position should the trust take if offered any large sum of money by the government. On the first point, it was generally agreed that the position which had been maintained to that date, that the Macfarlane Trust and its work was separate from the issue of compensation, was correct and should be continued. It was also agreed that while the Trust could not entirely avoid being drawn into the public arena on this subject, it should not take any initiatives or active part in the campaign. At the same time, the Trust should take care to avoid any action or statement which would impede the campaign. Now, that, as I understand it, was a view which, again, the Trust maintained during the period when you were chair, that it would not become involved in campaigning. Why was that?
Yeah, I think that paragraph says it admirably.
But why?
I think it goes back to what I said before, that if we got involved in campaigning, we would be, as it were, biting the hand of our paymasters. We preferred to take the money, however inadequate, rather than risk losing that money.
So I note the time. I'm going to move to a slightly different topic. So would this be a convenient moment to take a break?
Yes, so we'll take a break in a moment. Just a couple of questions arising out of the exchanges with Council thus far. The first was the making contact with the registrants, which was through their haemophilia centres. Can you help with how contact will be maintained from those who were not themselves receiving treatment, but were the relatives or dependents of those who had been infected but no longer were?
I think we took the view that the relatives of the deceased would still be known to the haemophilia centre, that there were continuing contacts between the centres and the bereaved relatives.
Yeah. And the second question, it's something of a lawyer's question perhaps, but the undertakings which were required as a condition of payment from the special payment trusts were checked by the administrator to ensure that they were there. Who was the undertaking made with? Was it made with the trust or with some other party?
I'm sorry, I didn't quite get the thrust of your question.
Well, there are two possibilities. One is that as a condition of receiving payment from the trust, the individual person seeking payment would have to sign a waiver.
Yes.
That is, a document prepared effectively by the trust for them to sign before they get the money out of the trust. That's an obligation then being undertaken to the trust. The other is that they sign the agreement as part of a settlement reached with the department or the government, with the other party in the litigation, and in which case what the trust will be looking for presumably will be evidence that had been done. Can you help as to which it was?
I think what we was doing with, I think the first of your options was what we were doing. There was a form, a waiver that was attached, formed part of the application form, which had to be signed. The wording on the form was as agreed between the solicitors or the lawyers for the litigants and I suppose the department with Macfarlane Trust's acceptance that we would make sure that these forms were appropriately signed.
Yes,
Sorry, I'm not sure that I'm really understanding the distinction between your lawyerly points.
No, it's a matter which I think I should take up elsewhere rather than delay this part of the evidence, which is on something which may matter, but for the moment we don't need to, I think, resolve it further. Perhaps, Ms. Richards, we can have a look at that in due course, and a lot will depend upon the particular wording, I suspect, of the waiver and who had the right to enforce it.
Yes, absolutely.
But
Can I just say that precisely the same tariff and waiver was a precondition to people becoming registrants of the Island Trust. But there, the application and the waiver is the correct completion of the application, including the signature of the waiver, was something which the Island Trust were not involved in. It was something that was administered by the department or their lawyers. But otherwise it's identical.
yes, thank you. Well, we'll take a break now until 10 to 12.
So yes, and Mr. Stevens will require the explanation about
He
not
will.
talking about his
Mr.
evidence.
Stevens, I don't know if you've watched any of our proceedings before, but if so, you will have heard me say to every witness who is being questioned at the time that we have a break, that during that break they must not discuss the evidence they have given or any part of their evidence which they think they may yet be asked to give with anyone, whoever it is, and however innocent they may think it to be. That's without first asking the permission of me to do so. You can discuss anything else you like, so it's not a question of being put in purdah. But those are the rules, and they'll apply at every single break that we have, because the chances are that you'll be back with us, I think, tomorrow.
I understand completely.
So 10 to 12.